Some would say, well, this could allow Governor Scott, if he's reelected, and he's on the way out, to stack the court in favor of conservative justices or Republican justices. But on the other hand, if former Governor Christ is elected as a Democrat and he is the outgoing governor in 2019, that could also apply to him, correct?
Yes, I have no idea which party this constitutional amendment will ultimately favor, and I really didn't look at it through the prism of who it would benefit. I chair the Judiciary Committee in the Senate, and I was informed that this problem was out on the horizon, and I thought this was the opportunity to address it before we knew who the particular personalities were going to be that are governor in 2018 and 2019, and to try to address it based upon some jurisprudence we have from former Supreme Court rulings that direct us as to the powers of the governor up until Inauguration Day.
Looking back over cases and so forth in the past, what did you learn about this kind of situation?
Well, there's not a lot of cases, but the two that are out there are one from 1955, which authorized an outgoing governor prior to inauguration of the new governor to make an appointment on Inauguration Day of a county court judge. What that court ruled was that the outgoing governor remains the governor even after Election Day until his or her successor takes the oath of office, that's an integral part of being qualified to serve as governor, or any constitutional position for that matter. The other case was in 2006, where the Supreme Court was asked, when does the vacancy occur? And they ruled that the vacancy occurs on Inauguration Day. So there is no case on point that directs us exactly which governor has the right to make the appointment, but Justice Quintero, in a concurring opinion at the time, said that there's nothing in the Constitution that precludes the outgoing governor from beginning the judicial nominating process, which would narrow the list down to 3 or 6 justices from which the governor would choose. The question remains, which governor has the right to make that choice? And this is a decision that has yet to been addressed by the Supreme Court, and were thrown to the Supreme Court in 2018 and 2019 in this conflict. You know, there are too many unanswered questions about, would the Supreme Court have to recuse itself? Would the outgoing justices have to recuse themselves? How would the court conduct its important business while this dispute was taking place and resolving itself in our courts? And so, to me, it made a lot of sense to be proactive at a time when we didn't know which party or individuals this might benefit, and address this to clarify so we don't end up with another presidential election crisis here in Florida over our Supreme Court.